Good afternoon and welcome to another AgForce webinar. Today's topic is CSG and Biosecurity and my name is Daniel Phipps, the CSG Project Leader, and I will be your host this afternoon. Before we start, just a few housekeeping matters. First of all, this webinar is a listen-only webinar. However, if you would like to ask questions, and you're please encouraged to ask questions or share your experiences throughout the webinar, if you'd like to do so, in the bottom left-hand corner of your presentation screen, you'll see a chat box. In the chat box, you can type in any suggestions, comments, questions or feedbacks, and you're encouraged to do so throughout the webinar. If you're having any problems or difficulties hearing the audio on the webinar, please call 1-800-896-323 and enter your participant code, and that will allow you to listen to the webinar over the phone. If you're still having any audio problems or other technical problems, please call Redback Client Support on 1-800-733-416 and quote your participant code for technical support. At the conclusion of the webinar this afternoon, you will be prompted to ask and answer a series of questions as part of an exit survey. And I ask you to please take the time to do that this afternoon when we finish, as it allows us to gather valuable feedback to improve and develop further on these series as we go through. The webinar this afternoon, I'd just like to point out, is designed for Queensland landholders. So we have got a number of participants logged in from other states of Australia. And I'd just like to reiterate that the information that's provided, the legislative context that this information is provided in, and as well as the conduct provisions in relation to company activity is also all relevant to Queensland. However, if you'd like any information from a more broader perspective, you're still encouraged to contact the project team for any information. It's important that you understand this session only provides an overview of information and should not be used in lieu of legal or other professional advice for any landholders that are dealing with CSG activity or going through the process of negotiating agreement. So I'd like now to get started. I hope that we'll be finished by about 3 o'clock, but that will depend upon the number of questions and how we go through the presentation, but I'll be doing my best to keep to time. I'd also like to point out that the webinar is being recorded, and following the webinar, within the next week or so, you will be sent an email which will contain a recorded copy of the webinar. So if you do need to leave the webinar at any point this afternoon, please feel free to do so. And you still will have access to that information after today's webinar. Just to quickly explain about the coal seam gas project that I head up, it's a project that we've been running since 2011 and is funded in partnership with the Queensland State Government, the Queensland Resources Council, APIA and the Gasfields Commission Queensland. What it does is it provides landholders with information and support throughout all stages of the negotiation and management process of CSG and resources, through developing support webinars, providing information to landholders in workshops, as well as technical field days covering off on biosecurity and groundwater. We also liaise and work with government, researchers and agribusiness to provide more information about landholder experiences, as well as help landholders develop property computer maps to use as tools in the negotiation process. The other projects that AgForce Projects head up are our feral dog and wild dog coordinating project, as well as the grazing BMP best management practices program. And if anyone would like any more information about the other services that AgForce and AgForce Projects operate, I encourage you to contact our Brisbane office on 3236 3100. What we will be covering today is coal seam gas and biosecurity in Queensland. I'll be providing a quick overview of some of the CSG activities in Queensland. I'll also be taking you through the biosecurity framework for resource companies, as well as some of the landholder considerations to take into account when negotiating a conduct and compensation agreement, and also looking at some of the things that you can do as landholders or those of you advising landholders moving forward and as the industry continues to develop, as well as indicating where you can get assistance and when you have issues, where you need to go to get those issues resolved. Wrong way. So when we look at the CSG industry in Queensland, since the development of this project in 2011, we've seen a significant increase in the number of wells that are being developed across the state, and that really typifies the rapid expansion that the industry has been undertaking over the last 4.5 years. What's important to understand is that when we look at the number of production wells, the top column, in 2015, just being over 5,500, it's important to take this number into context when we look at the number of wells that are likely to be developed across the industry over the lifetime. And that number is anywhere from 18 to 40,000 wells. So what that really shows is that we've got a lot of activity yet to come, and we're signifying to landholders and those working with landholders that although there's a visible ramp down at the moment, it's important to understand and recognise that a lot of wells are still yet to be drilled and a lot of infrastructure is yet to come. And that's critical why landholders need to remain informed. When you look at the map on your screen, and please tell me if the slides are moving slower than my audio, the map on the screen shows you the 3 basins that we talk about in Queensland. The green basin being the Bowen Basin, the blue being the Surat, and the pink being the Galilee Basin out in Western Queensland. The individual dots in red and black signify coal seam gas wells that have been drilled so far over the life cycle of the industry. The black wells represent CSG wells that were drilled as of April 2011, and the red dots represent wells that have been drilled since April 2011 until July 2015. What this shows you is that there's been a significant development of activity across the Surat Basin as the primary focus of CSG, but there's also been activity occurring in the Southern Bowen Basin, the Central Bowen Basin, and the Northern Bowen Basin, and some exploration activity occurring in the Western Galilee region. Again, taking into account that this is roughly 5,500 production wells, it's important that landholders and communities continue to remain informed and aware as the industry and legislation develops to look at what 18 to 40,000 wells may look like. For landholders and those working with landholders, there's a number of different information sources that you're encouraged to find this information. To find information about the tenure, so which company holds the permit over your property, whether it be coal or mineral or CSG, the current gas wells or coal boreholes that are being drilled, as well as the groundwater data, which is a topic that we'll cover in another webinar soon. The 3 main sources of information that you're encouraged to access is called the Coal Seam Gas Globe, or the CSG Globe, which is part of the Queensland Government's Queensland Globe, Mines Online Maps, and the OGIA, the Office of Groundwater Impact Assessment, or the Department of Natural Resources and Mines, DNRM, Groundwater Bore Search. Now, we won't be talking about groundwater today, but there are 3 portals that landholders are encouraged to use to find more information. And at any point throughout the process, the AgForce Projects CSG team can help you to use these portals to find out more information about your property or about your region. Now we're starting to talk about biosecurity, and we're going to delve into the topic in a lot more detail. What's important to consider is that CSG, it really is one industry among many that are now operating in the same landscape when we talk about the Maranoa, Western Downs, Banana, and the Bowen Basin regions. It's important that landholders and other community members also look at the other external operators in these areas, such as power and utility companies, local and main roads, council, any other resource operators, small-scale fossicking or prospecting, and basically looking at any other entry of external vehicles or equipment to the property that may pose a biosecurity risk. And when we talk about biosecurity, it's important to recognise that we're talking about weed seed, but also pathogens and organic materials. The focus, obviously, of today's webinar is talking about the interaction between coal seam gas and landholders. And I want to talk now about the obligations that resource companies have. In 2010, the Queensland Government developed the Land Access Code. And the Land Access Code is a document that sets down mandatory provisions that resource companies and landholders must comply with, in particular reference to weed and pest management. Of important point is noting that resource companies, as it states there, have an obligation when the risk of spreading or likely to reduce that risk by spreading is reduced by washing down equipment, then the company must first of all, ensure that all employees and contractors wash down vehicles and equipment before entering the property, and that they must also maintain a record of all of these washdown certificates, and importantly, when asked by the landholder, that those records be presented. In the Land Access Code, it talks about the washdown process, meaning the removal of reproductive material from a vehicle or machinery and using an appropriate cleaning process. What's important to understand is that this mandatory provision under the Land Access Code applies to all activities that the coal seam gas company would like to undertake. However, when we talk about coal mining companies, it's important that this is a process that only applies at the exploration phase. And once a coal company moves into production, the obligations of the Land Access Code no longer apply. When we look at some of these obligations under the Land Access Code, there are 2 points that are of key concern to landholders. The first of all is to look at including about the requirement to provide washdown certificates when requested, but also the third point, moving forward to a more specific requirement about, well, what is actually included in a washdown process. And that's something that we'll expand on as we go through the webinar. When we look at the Land Access Code, and if any landholders that are dealing with resource companies who have not seen or read the Land Access Code, I strongly encourage you to download it. You can download it from the AgForce website, or you can download it from the Queensland Government website simply by typing into Google or a search engine the Land Access Code. What it talks about is putting in place some ground rules that the resource company must take all reasonable steps to ensure that those employees or those that are carrying out authorised activities on behalf of the company do not spread the reproductive material of a declared pest, but also critically importantly, ensure that when they're entering or leaving an authority, such as a tenure area, that they do not spread that reproductive material. And this is when we're talking about clean vehicles, clean equipment, and monitoring things on and off property. It's important to understand in the Land Access Code, it talks about declared pests and weeds. And this is particularly made in reference to Schedule 3 of the Land Access Code, where it talks about what actually is a declared pest. And it stipulates that it's a declared pest that's under the Land Protection Act 2002 in Queensland Schedule 3, or in the second point, any animal or plant that's declared under a local law to be a pest because of the potential the plant or animal has to cause harm or a social or economic impact. And this is where it's important for landholders to be involved and their advisors be involved in the negotiation process to actually look at stipulating and clarifying particularly what are the weeds of concern on property and how do you go about identifying those. But again, when we get to the negotiation provisions, this is something that we'll expand upon. This is just setting the regulatory framework at this point. The CSG industry in Australia and in Queensland also has their own set of industry standards and the guideline that they have developed, which works in addition to the Land Access Code, which sets down a best practice standard and a minimum standard that resource companies must apply with and must adhere with. And it's also important that landholders understand that individual companies will often develop their own weed management plans or their own washdown certificate plans, and that in your negotiations or in your discussions with the resource company, that the resource representative take the time to explain to you what their process is as a company and take the time to explain to you how they can ensure that they will comply with the conditions of the Land Access Code, but also the industry best practice guidelines. And as a resource representative, discuss with the landholder, do these meet your requirements? And if not, what can be done better or what can be done further to make sure that your property is safeguarded against any biosecurity risks? When we talk about the land access process, moving into a more focused landholder experience, it's important to understand 2 points. The first point being that it's very unusual for a property to maintain the mineral or the resource rights under the surface of the property. And the reason being that generally these resources are held held by the Crown. The Crown reserves the right to hold and manage these resources, and manage these resources for the benefit of all Queenslanders by charging a royalty. However, it's critical that everybody understands, both companies and landholders, that even though you may not own the resources under the surface of the earth, it's important to understand that you do own the access route, you do own the surface property, and you still own those property rights, freehold or leasehold otherwise. And it's important that as a company, they must understand that they cannot unreasonably interfere with your lawful activity. And this is where we talk a lot about the rights and responsibilities that landholders have to develop agreements with resource companies in this process. And unless the resource company has either gained your consent by signing an agreement or has taken you through to the land court and the land court provided a determination to enter the property, then they can't come on and carry out those activities. When we talk about resource activities, there are two particular types that landholders need to be aware of. The first one is called preliminary activities, and these are activities that are signified when a landholder receives what's called an entry notice. Now, an entry notice for exploration activities can last up to 6 months unless you agree to a longer period of time as a landholder. Now, these preliminary activities are activities that are designed to have little to no impact. That being, as it says on the screen, sampling by hand, walking existing tracks, carrying out fauna flora surveys, and also scouting potential sites. So no activities that are designed to have any sort of impact to the property. It's important that you understand that at this entry notice process for these preliminary activities, that an agreement or a conduct and compensation agreement, as it's called, or a CCA, is not required prior to entry. That being said, even though an agreement is not a mandatory requirement at this stage of the process, it certainly doesn't mean that as landholders you don't have the right, or that you shouldn't at least consider and discuss some points with the resource company. The first point is to look at the entry notice timeframes and how do they fit with your existing activities, and making sure that your existing activities are harvesting or mustering or planting, those activities aren't disturbed by the company wanting to gain access. And if they do want to gain access, negotiate or request a more suitable time that you can be present for those. The second point is important to expand on exactly what activities, who will be undertaking them, when will these activities be taken out, where will they be located, and for how long. And this is a real point of confusion where a lot of activities are undertaken without actually the landholder or the company taking the time to explain to the landholder, to actually get them to clearly understand exactly what those activities are, what the planned activities will be and what they'll look like, and importantly, what any impact will be from those activities. Of particular point today is obviously biosecurity concerns, and looking at discussing with the resource company representative, understanding exactly what is the washdown process of washing down vehicles before they access the property, and looking at where will workers be accessing on your property, where will they be coming from, and what are the biosecurity risks that those activities or those entry points pose particularly to your property. And obviously weather is a particular concern for landholders, so not accessing properties within at least 24 hours after wet weather events, or probably a positive approach is to put in place a requirement that the resource company representative check weather conditions with you at least 24 hours prior to entry to remove the risk of any property or track damage, but also to lessen the risk of bringing on muddy or dirty equipment when we're talking about resource company activities. When we move to the next stage, which is the negotiation process, this is where the most time is spent from our experience. So this is when you've gone from those preliminary activities, or for some of you, this may be your first point, and this is when you're actually negotiating an agreement or a conduct and compensation agreement, a CCA. You're actually negotiating an agreement for the activities that the company would like to undertake. And these are for the activities such as drilling wells, clearing vegetation and roads, building tracks, realigning fences, and also looking at some of the heavy seismic activity. And this is a process, as you can see on the right-hand side, that there's a graduated dispute resolution process and that there's a very specific land access framework that applies, and it sets down minimum timeframes for you and the resource company to proceed through before either an agreement is signed or before the matter can go to the land court for the matter to be heard. When we look at the land access key points, and I won't be spending much time on land access today, that's another topic to talk about. We'll continue to hone in on biosecurity. The three key points to take away, however, that are relevant for this afternoon's discussion is that before the company can undertake those advanced activities, they must negotiate with you an access arrangement or an access agreement, and that's known as that conduct and compensation agreement, or the acronym being CCA. It's important that you remember that there are minimum timeframes in place for this process, and there's no framework that allows the company to proceed straight to the land court. So the company representative must step through the negotiation process with you as a landholder before going straight to that process. It's critical that you understand that these agreements, these CCAs, cover both compensation for the activities and their impacts, but also importantly cover the conduct, and that regards about how the activities will be carried out, where the activities will be carried out, and also putting in place property-specific considerations about when and how those activities will be carried out and how the impacts of those activities will be mitigated. And that's specifically when we talk about biosecurity provisions. Into the negotiation process, it's important that we really do reiterate that the two components of an agreement, of a CCA, are very distinctly different, and that being conduct and compensation. A few key points to understand is that your agreement attaches to your land for the term of your agreement. So your CCA doesn't just stop with you unless you specifically put that clause in your agreement when you sell the property. And this is an important process when we move into the compensation process. When we look at timeframes of activities or review periods in agreements, it's critical that either both are included or at least a review period is included in your agreement. And that is specifically important when we talk about biosecurity, and particularly important when we look about progressive rehabilitation. So the process of progressive rehabilitation is a requirement that will ask you to sign off on activities after a certain period of time after rehabilitation activities have been completed. And it's important in your CCA access agreement that you include review provisions in your agreement to make sure that the adequacy of that rehab is being done properly, or more importantly, making sure that your agreement conduct considerations or that your compensation in your agreement adequately covers any impacts that are occurring, or if any impacts that are occurring outside of what the original agreement covered, that there's obviously an ability to renegotiate to make sure that those consequential impacts are covered under the agreement process. When we talk about biosecurity, there's a lot of different considerations for landholders to take into place, and we just wanted to provide you this afternoon with a quick guideline about some of the considerations to consider, or for those of you working with and advising landholders to be aware of some of these considerations in your dealings. One of the most important points that we consider through this process is that landholders consider carrying out or negotiate with the resource company that conducting a weed baseline assessment should be done prior to any land access conditions being granted or prior to any activities commencing on the property. And this is a really important point to consider for landholders to be able to demonstrate any impact to your property or any detrimental impact to your biosecurity provisions or to the weed burden on your property. It's critical, obviously, to have a baseline reference point, because without having a baseline reference point, it can be quite difficult to determine where that impact came from or determine that impact as a result of CSG activities or CSG vehicles accessing the property. The Gasfields Commission Queensland has developed a baseline assessment checklist in conjunction with the Department of Agriculture and Fisheries in Queensland, and it provides you with an excellent starting point to be able to go through some of the considerations that look at what landholders should be including as part of a baseline assessment and what are some of the things to capture as part of that process. It's important that you consider the growth period or the seasonal conditions at the time that this baseline is carried out. So if a baseline assessment is carried out under dry conditions or conversely under wet conditions, does that baseline assessment really show the actual weed burden or current weed burden on your property or the weed status of your property in a more general term? The example to provide is when you're looking at doing a baseline assessment for groundwater supplies or a bore, for example. If you did a baseline assessment, a one-shot snap condition report of your bore in the middle of summer during a very high drought, it's probably not as likely to show the true capacity of your bore to supply water to your property. There's obviously a higher likelihood that other people are pumping, that aquifers are putting out lower pressures or less water is available, and it may be showing a condition report that doesn't truly reflect the capacity of your bore. And the same example exists for biosecurity. It's important to consider the growth periods and also the seasonal conditions that that baseline assessment is carried out under. The second point we talk about is developing a property management plan. And as part of a property management plan or a property map, identifying and mapping out high-risk weed areas on your property or establishing any outbreak areas or any areas that already have a high weed risk. When we talk about weed risk areas, we're particularly looking at access points, overland flow, high access roads, road easements or stock reserves, any areas that border an area that may have a high weed burden, such as neighbouring blocks that aren't as well looked after, or any road reserves or main roads that may have weed risk areas. And obviously identifying with the resource company preferred access locations, access points, and also looking at appropriate weed control around these high risk areas. This is also, for a lot of you, a trigger to develop your own weed management plan or your own property biosecurity plan. Now we understand that a lot of producers are already taking, and for a number of years, have already been taking positive steps to managing biosecurity or managing weed issues on property. But this is a process that's actually looking at getting you to document those processes and procedures that you already do. And by documenting it and having it as part of a property plan, it allows you to use that as a tool to demonstrate very, very clearly to your resource company representative what it is that you're already doing and demonstrating how the resource company activities shouldn't be able to impact on those existing activities. And this is a process that AgForce can help you with. We can help you develop property management plans, we can help you develop property maps, and we can help you develop property biosecurity plans. And using the Gasfield's weed baseline checklist, we provide you with a lot of tools that you can use. One question that we point out in the last point is to look at establishing responsibility in your conduct agreement about if there's an outbreak or if there's a disturbance of weeds, exactly what's the process to rehabilitate that process, or what's the process to actually control and remediate that area. This relates importantly to distinguishing between weed or biosecurity risks being brought onto the property as opposed to those that are just disturbed from activities being on property. So when we talk about dirty vehicles being brought on or machinery or weed material being brought onto the property, we're trying to make a distinction between, well, there may have already been weeds in the seed bank, but because of the activities by the resource company to clear and disturb that area, they may be the first thing to grow back. And when you look at that process, the company didn't bring them on, but their outbreak is as a result of the disturbance of their activities. It sets in place a distinction between what's being brought on and what's being disturbed. And this is a process that you need to discuss with the resource company representative. When we're looking at expanding on the baseline assessment, it's important that we look back to the Land Access Code, and the Land Access Code talked about identifying obligations for declared pests and weeds. But for a lot of landholders, the list of declared pests and weeds are not just the extent of what you're most concerned about. What you're most concerned about is any weed or any pest that's an impact to your property. And the first point looks at either in your biosecurity plan, either identifying the high risks or the weed species that you don't want, or the other option, the easier option, is identifying the only desirable species that you would like on property and that you do have on property, and that anything else outside of that scope is considered a weed and places an obligation on the resource company and any other representative to manage that proactively. It's also important to look at traceability. And traceability for biosecurity looks at either vehicle registry for staff, equipment and vehicles, and being able to be aware of what's on the property and what's being brought onto the property and looking at the weed-free status of that equipment. The last point looks at any withholding periods from a traceability perspective and making sure that as an industry we're aware of any withholding periods or any workplace health and safety risks that any control materials that are being used on property present to either your livestock or to yourself or to your employees or to your family. And it's an important process when we talk about materials that are being brought onto the property for control purposes, particularly when we talk about organic properties, being able to maintain a list of equipment and materials that are brought onto the property, but also being able to maintain traceability in case there's a contamination risk or spread. When we talk about the rehabilitation process, we're returning back to the earlier point in the land access framework, where we're looking at review provisions or review conditions or terms of agreements being included to look at the ability to require progressive rehabilitation or to require you to sign off in these areas as they work. And the question that would ask is how long after that rehabilitation process is the resource company responsible or liable for maintaining that area or for any subsequent weed outbreak that may occur. And this is a particular point when we're looking at, based on assessment, looking at the conditions of the seasonal conditions and growth periods, but also as a landholder or those of you advising landholders to consider obviously the time in which you're being asked to sign off on that rehabilitation. At what point after the rehabilitation period has there been any rainfall events or has there been enough growth period to truly monitor the effectiveness of this rehabilitation work and making sure that any weeds that were likely to spread would have made themselves known, and if not, the question would be, would you release that process or release that requirement from the company? Of particular importance to landholders is obviously looking at the washdown certificate process and looking at what should actually be included in a washdown certificate. Some of the points of consideration is to look at requiring a kilometre reading be included on a washdown certificate at the point of washdown. Making sure that the date the vehicle is washed down is also provided, and also detail what was actually included in the washdown process. And it's important to understand in your discussions with the resource company representative exactly what is their washdown process. Do they have, in the example shown, a wet wash or a high-risk wet wash versus a low-risk wash, which may actually just be an air dryer or a shakedown. Now, you as a landholder, does that process or that procedure meet your requirements or reduce the risk for you to feel satisfied that all steps have been taken to reduce or lower that risk? It's also important to understand who has inspected it, where was it inspected and who was it certified by. And the last point, obviously looking at identifying and understanding the area that the vehicle has travelled since receiving its washdown certificate. So obviously you'd be concerned if a vehicle is washed down in a main town and travelled a number of or hundreds of kilometres from the washdown facility to enter your property, and you'd be questioning what potential material has that vehicle picked up on the way through and what risk does that present to your property. What this process is really about is about identifying risks identifying the potential sources of these risks, and then going through a process to be able to mitigate, manage, or remove or lower that risk as best as possible. And when you look at the washdown process, that's a process that is designed to really meet the requirements of doing that. And the last point is to look at, are you satisfied with these processes that are being put in place to reduce these risks? Prevention is better than reaction. One of the important tools that we encourage all landholders to develop is to identify these risks through the development of a property plan, and a property map is a critical place to start. The example that we've provided is to overlay the proposed CSG activities and infrastructure over your existing property map and look at locating the development areas and the disturbance areas as particularly high risk areas or high focus areas for carrying out a baseline assessment process. Going out with scouting parties to determine the location of wells and roads and infrastructure, and making sure that you and the resource company representative, or you and the resource company, both have the authority to agree what was there, what was noted, and what species were not present, and basically look at the general weed burden that your property is experiencing. And if there's no weed burden, then obviously you're putting a higher risk factor on your property from any disturbance. The second point of using your property map to identify and risk any high weed risk areas, and obviously looking at how that interacts with the proposed activities that the resource company would like to undertake. And if activities or access points are located in high weed risk areas, then is there a possibility or is there an ability to negotiate a preferred or better location or timing of activities, or look at including possible portable washdown facilities, or making sure that vehicles and equipment are washed down thoroughly before being brought onto the property, that you inspect and approve of that equipment being brought onto the property, that you're paid for your time to do that process, and that equipment and activity stays on property for the duration of those activities and that development schedule. And then once the activities are completed, then the equipment moves off property, and you're greatly reducing that biosecurity risk by vehicles and equipment not constantly entering and exiting the property. The third point relates to the whole process of identifying any current weed areas that you're aware of, any disturbance areas, and obviously mapping out any areas that you're particularly concerned about, looking at neighbouring properties, regional areas, or local infrastructure. AgForce has developed a number of different baseline assessments, a number of different baseline checklists that you can use throughout all the negotiation process, from groundwater to roads to weeds to biosecurity to noise. And we encourage you to access the information on our website or to contact the project team for any particular information to expand on this information. It's important to understand that the information that we've provided is the starting point, that there's a lot of information to go through the negotiation and biosecurity process, to groundwater to surface water, to make good and complaints resolution. We've tried to summarise these as best and as simply as we can into the main stages of the process you may step through, from the entry notice process of preliminary activities to signify what are preliminary activities, understanding that there's no agreement that's required as part of this process, and that there's still an ability, even without this agreement, to make sure you have a say on the timing, location and extent of those activities and when those activities should be carried out. When we look at the second point of advanced activities, making sure that there's an agreement, a CCA, that is required prior to the entry or those activities being carried out, understanding that your necessary and reasonable legal, accounting and valuation costs are reimbursed by the resource company in order to negotiate that agreement, and that you spend the time to consider all of your property-specific conduct provisions. And that's a really important point that we spend a lot of time with in our negotiation webinars and workshops with landholders one-on-one. The third point is looking at the long-term process of these agreements, making sure that there's ability to review agreements if impacts change or as activities change, making sure that you have appropriate compliance provisions in your agreements to look at any breaches of agreements, and also making sure that you have monitoring included as part of your process. Some of the key points that's important to understand in wrapping up in relation to this process is that confidentiality is not a mandatory provision. No confidentiality is a mandatory requirement as part of your CCAs. And it's important to understand that if there's a material change in activities, then that CCA must be updated to reflect those activities. For those of you who have already signed CCAs or have had activity on your property and are not sure what's in your agreement, it's important to go back and understand the term of the CCA. Is it for a specific period of time, for a specific number of years or number of activities, or is that agreement for life of tenure? And if so, when does that tenure or when does that permit expire? It's important that everyone understands exactly what activities does your CCA cover. Does your CCA cover X number of wells, X number of kilometres, and X number of seismic activities, or is it very open-ended and it provides the company with a lot more scope? When we look at the last point, it's critical that reviewing the effectiveness of the agreement and reviewing the effectiveness of the process to manage activities in the agreement is a critical point for everyone to be aware of, and to be able to periodically review the effectiveness of weed management processes to identify if washdown certificates aren't working, or to identify if weed management procedures aren't being followed, or that outbreaks aren't being controlled as effectively. You need a trigger, or you need an ability in your agreement to be able to automatically and immediately rectify that situation, rather than waiting for drawn out long negotiations. But putting in place a clear, concise review period or a trigger or review trigger in your agreements is something to address these conditions. In closing the webinar, I'd like to indicate that it's critical for landholders and those of you that are advising landholders that there are dedicated staff within the Coal Seam Gas Compliance Unit within the Department of Natural Resources and Mines that have been set up as a central point for handling and receiving landholder complaints. So whether your complaint relates to land access procedures, groundwater complaints about bores, company behaviour, or general concerns as community, or if you've identified anything as a biosecurity breach, or that resource companies, representatives or contractors are not complying with biosecurity provisions or processes, and you're not satisfied with the response that you receive from your resource company, then you should contact the CSG Compliance Unit. And the CSG Compliance Unit, the number and email are on the webinar screen, and we'll also be sending out the direct contact details for the Compliance Unit following the close of this webinar in the summary email in the next week. At all stages of the negotiation process, you can contact the AgForce CSG Projects Team. Myself, my number and the email are provided on the screen, and you'll also be receiving my direct contact details in the webinar summary to follow. This is a free service that's provided to all landholders throughout all stages of the process, and whether you're chasing some general information about industry issues, or whether you're negotiating an agreement and you need some support, you need some advice, or you've got issues resolving activities on property, the experience and the knowledge that the project has developed over the last 4.5 years, we've seen over 4,500 producers. We can impart this knowledge and experience onto you as landholders. So we strongly encourage you to use that information, to use those resources that are available, and to use the services that are here to help you as landholders. In closing, I'd just like to say thank you very much for everyone who has registered to attend this webinar this afternoon, and everybody that has logged on to register for the webinar. If there's any questions or comments, or if there's any particular points that you'd like me to reiterate or go back over before we close, that'll be, now is the time to type them in the chat box, please. Alternatively, you can contact myself. My email address is fitsd@agforceprojects.org.au with any particular questions or concerns or comments. And also you can contact the Brisbane office on 3236 3100 if you've got any particular questions that you'd like to help through the process. The funding that we have for the project provides us with funding up until the 30th of June next year. And outside that process, we're not sure of the continuation of that funding. So we strongly encourage all of you with questions or that are dealing with this process to use these free services while they're still available. As there are no questions that are coming in, I think we can close the webinar this afternoon, and I'm glad that we've maintained the time. Following the webinar, you'll be prompted to complete an exit survey when we close the webinar, and I'd please ask you if you could spare just a few, it'll only take a few minutes, just to quickly do the exit survey, just to make sure that if there's any information that you need further following the webinar, or if there's anything that we can provide from a particular topic point of view or further support, we need that feedback and that monitoring advice to make sure we're delivering the right information to those that need it. So thank you again for logging on. I appreciate you coming and giving me your time, and we'll hope to be in touch in the future. Thank you.